girls. Uh, in continuation to what we did last time, I would like to first explain the term ex post facto laws. Okay, the term which I in my last class did not tell you, could not tell you because I was myself not aware of what ex post facto laws means. So actually, ex post facto law वो होता है when an offense is done. If you did the offense today, you should be judged according to the law of that particular day or that particular present scenario. उस समय पे जो भी laws हैं, only those laws could be dealt with. Not if you are charged uh, as the laws made later on the same issue. So that means, supposing I've been imprisoned and there are certain laws which give me the restriction for maybe 5 months. Okay. And these are the applicable laws. But after, say, the trial is on, and after, say, a year or so, supposing there are amendments that you cannot hold a person for more than 3 months. So now those laws would not be enforced in my case. Why? Because ex post facto laws means those laws will be applicable for that particular case on the day it was put forward. Okay? So that was the meaning of ex post facto law, which we read in Article 20. Okay. And while I was going through, I found out two new terms also. One was prospective nature, and the other is the retrospective nature laws. Clear? Now, prospective nature laws are those laws that which say that if the law is made on a particular date, it will be applied from that day. That means prospective laws. Then the other is retrospective laws. Now, these laws are made today and can punish a person for a sin done before the law was made. These are the retrospective. That means whatever laws are made, even if they are made in a present day scenario, and the person has been tried earlier before these laws were made, in certain cases, these retrospective laws come into force. That means you will be dealt according to the present day laws. Okay? And while we were doing Article 21, which talked about the protection of life and personal liberty, we covered upon the rights given to the elderly people, how they are given, the senior citizens are given rights for their maintenance, for the looking after their health, and adequate pension to be received, etc. And then we talked about the privacy as an integral part of a law under this heading. Then we also talked about the reproductive choices made by a female, whether she wants to give uh, birth to a particular child, or she wants to abstain from giving birth. नहीं देना चाहती है जन्म. So all those rights are controlled totally in the hands of a woman. So she gets the special privilege, and nobody can compel her in doing so or going against. And in that case, we came across a case of Suchitra Srivastava versus Chandigarh administration. Now, this was a very typical case where this girl, she was mentally retarded, and the judges had to look forward that what could be done. And she was living in an orphanage. Firstly, she was in Delhi, then she was later on in Punjab, sorry, Chandigarh. So there, in that particular place, living in among the female welfare associations, she was living there in an orphanage with nobody to look after. There was no family member to look after. So the judges, they decided that they would terminate this pregnancy. Terminate means put an end to the pregnancy. Why? Because she was raped in that case. And she being mentally sick or retarded, uh, the judges decided that it would not be in her favor, that she would not be able to protect the child, neither she would be a good mother because of her illness, of not being able to comprehend how this happened. And that activity, it was a rape, it wasn't a mutual understanding that she went forward for. and neither she was aware about the sexual changes and the bodily changes, or after the birth the consequences. So keeping all this in mind, she wanted to the judges wanted to terminate the pregnancy. But then at the same time, termination of pregnancy cannot be permitted without the consent of the victim. And in this case, she was really a victim. Actually, the law says that the termination of pregnancy cannot be permitted without the consent of a female. But here, she was a victim. So, in spite of all odds, the judges could not uh, give a confirmation. And then, on top of it, later on in her later stages, they came across two clauses. Firstly, the weeks of hearing were prolonged, and it was her 19th week, which was making it all the more dangerous for her to carry and then later on get the abortion done. At the same time, she started showing inclination that she wanted to keep the baby. Though she was mentally retarded, but the concept that she would have a toy to play with, maybe, or any other concept she had in her mind, she was continuously showing the awareness that she wants to keep the baby. And so then it was finally decided in her favor, and the consent was given that yes, she could carry on, and the pregnancy was not terminated, and the judgment was passed. Now we come on to the next clause, the ninth clause, which says right to livelihood is an integral facet of the right of life. Now, anyone who has life has right to earn the way he wants to. Livelihood means the way you wish to live, and basically it deals about the economic aspect of life, कि आप पैसे रुपए से क्या जॉब ऑप्ट करना चाहते हैं अपने लिए, जो आपको आपकी जीवन के सार्थक होने में हेल्प करे या आपकी लाइवलीहुड में आपकी मदद करे. Then the 10th one says a boy and a girl married on their own will, they were majors, and the marriage was duly registered under the notified authority. The police officials have no role in their conjugal affairs, and the law enforcing authorities have no right to interfere with their married life. And in fact, they are duty bound to prevent others who interfere in their married life. So then the other right to life and property is that if a girl or a boy decide to marry and they are married, at first there are two main clauses. Firstly, both should be major, no one should be minor, that means underage. And at the same time, they've got the marriage duly registered. That means it is not just a fake marriage in a temple or any place of worship. It should have a proper registration done in a court. If these two clauses are fulfilled, then even the police has no right to interfere in their affairs, whatever their livelihood or whatever their decision is. In fact, it is the duty of the authorities to even check that their liberty is not hindered by any outsider. Then we come on to the 11th one. The word life in Article 21 means a life of dignity and not just animal life. That means that when you talk about Article 21 and you talk about life, and the word is the concept is protection of life. It means not just protecting कि आप सांस ले सको. It is more of you are given and provided a dignified life, not a miserable one that you are जी तो रहे हो लेकिन जानवरों की तरह तुम्हारे संग व्यवहार करके. So it has to be a dignified life. Okay. Then we come on to clause uh, heading 12, clause 4 of bylaws framed by cine costumes, makeup artists and hairdressers association, a registered trade union restricting membership of association only to men, makeup men, costume men, and hairdressers, violates Article 21 of the Trade Unions Act of 1926, for the act has not made any distinction between men and women. Had it made a bold distinction, it would have been undoubtedly unconstitutional. The legislature, by the way of amendment of Section 21A of the 1926 Act, has only fixed the age. The clause, apart from violating the statutory command, also violates the constitutional mandate, which postulates that there cannot be any discrimination on ground of sex. Such discrimination in the excess of employment and to be considered for the employment unless some justifiable riders are attached to it cannot withstand scrutiny. When the access or entry is denied, Article 21, which deals with livelihood, is offended. It also works against the fundamental human rights. Such kind of debarment creates a concavity in her capacity to earn her livelihood. So now they discuss about the discrimination on the basis of sex, which is denied when we talk of the protection of our rights. Now, there was a certain association of the makeup artists and the costume men, hairdressers, etc., and they formed a union, and in this they strictly prohibited the uh, women to participate in it. Now, this was not justified because it was talking about discrimination on the grounds of sex, whereas it gives an equal opportunity to all, irrespective of men or women. So this was one article, one such clause which was not heard, and it was rather deemed क्योंकि इसमें मेल और फीमेल कॉन्सेप्ट का आ रहा था, and any job has no restrictions कि ये particular male job है या ये female है. When we talk of equality of status, it should be given to both men and women. Then we come on to Article 21A, which gives which says for right to education. Now, the state, and this stands very important in nowadays scenario. So we talk of Article 21A, which says right to education. The state shall provide free and compulsory education to all of the age of 6 to 14 years in such manner as the state may by law determine. So here the important words or the key words for remembering this particular article are free and compulsory education. That means firstly it is talking about education. That too, the two adjectives in it, free hogi and compulsory hogi. That means they made it mandatory. Come what may, every child who's of the age between 6 to 14 has a right for education, and it should be given free, and it should be made compulsory to all the children of this age group. So the second clause which stands important is the age group 6 to 14, and it should be given in the manner which is under the state laws. That means every state should call it, it's their duty to give that particular article as a right to education. Then there are comments given here. First one, in order to ensure compliance of Article 21 of the Constitution, it is imperative that schools must have qualified teachers and basic infrastructure. So now they say to make this Article 21 very, very effective, we need to have qualified teachers, because a school cannot be run by anyone. So first clause, that if the children are being if the education is being made compulsory for the students or the children and free, so for first and foremost need is that the teachers should be well qualified for that institution. Apart from that, they should have a basic infrastructure which could be called a school where the children could come and assemble. Then the second point in the comments says, right of a child should not be restricted only to free and compulsory education, but should be extended to have quality education without any discrimination on the grounds of their economic, social and cultural background. Now this says it all कि आपको सिर्फ क्योंकि ये कंपलसरी है इसलिए एजुकेशन देना ही है, वो सिर्फ उतना रिस्ट्रिक्शन नहीं है, आप किस क्वालिटी की एजुकेशन दे रहे हैं. Are you giving the moral based values to the child or not? Or are you just making the child mug up a story or the syllabus? So apart from this, They enforced on, they talked about quality education as well. And the quality education, when they talked of this, very specifically had said that it should be not giving any discrimination to a child from the other on the basis of the child's parents' economic status, the social background the child comes from, or the cultural background which the child has. So irrespective of his economic status, social and cultural background, the child should be given quality education. Then we talk of 22, Article 22, protection against arrest and detention in certain cases. Now, once an arrest is made, agar aapne kisi ko bandi banaya hai, we have talked about it in earlier also cases. Last time when we were reading, here is a few more added article, one more added article for this. Then they talk of detention, for how long you can imprison a person whom you have arrested. Now, the first thing says, no person who is arrested shall be detained in custody without being informed as soon as may be on of the grounds for such arrest, nor shall he be denied the right to consult or to be defended by a legal practitioner of his choice. Now, again, this clause, the first sentence comes with a number of meaningful words which need to be incorporated when you're writing about this article. Firstly, they have said if a person has been arrested, उसकी कस्टडी को आप डिटेन नहीं कर सकते, बहुत देर आप उसे नहीं रोक सकते हैं, एंड उसको अरेस्ट करने से पहले उसे इन्फॉर्म करना है प्रॉपर कि उसको किन ग्राउंड्स पे आप अरेस्ट कर रहे हैं. You cannot just take up a person away and imprison him without telling him the cause of his imprisonment. तो आपको उसको इन्फॉर्म करना पड़ेगा कि किन ग्राउंड्स पे आप उन्हें डिटेन कर रहे हैं. Then the second very important thing is that he should be given a time where he could call upon a legal practitioner for his uh, of his choice, so that he can fight up his case against the all the allegations which have been made. उसके खिलाफ जो भी कार्रवाई की गई है उसके लिए वो एक लीगल प्रैक्टिशनर को भी बुला सकता है, ये उसके राइट्स हैं. Then the second thing they talk of is every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of the magistrate. So they are saying that if you have imprisoned a person on certain grounds and the grounds are plausible enough, even in that case, you cannot detain a person without making him appear before a magistrate for more than 24 hours. आप किसी भी person को जेल में 24 घंटे से ज्यादा बंद नहीं कर सकते हैं. You have to take him to the nearby magistrate, nearest magistrate, get the hearing done, go through the proper procedures. Maybe after that, if you find and you decide on something, it could be moved forward. But आप उसको 24 घंटे से ज्यादा, सिर्फ पुलिस के हाथ में ये अथॉरिटी नहीं है कि उसको 24 घंटे से ज्यादा डिटेन कर सके थाने में. Then the third clause says, nothing in clause 1 and 2 shall apply. मतलब कि 1 and 2 में कोई भी जो भी clauses दी हुई हैं वो apply नहीं करेंगी. किन किन cases में? To any person who for the time being is an enemy alien. ये उन पर apply नहीं करेगी कि अगर जो person हमने जिसे पकड़ा है वो कोई हमारे दुश्मन या बाहरी दुश्मन का है. ठीक है? Supposing we the person like this Kasab we had captured as a terrorist he was. So in that case, the police had the right to detain him for more than 24 hours. Then the second clause says to any person who's arrested or detained under any law providing for preventive detention. अब उन्होंने बात की है कि अगर हम ये कर सकते हैं 24 आवर्स से एक्सीड कर सकते हैं इन अ केस अगर उसको हमने डिटेन किया किसी प्रिवेंटिव डिटेंशन. प्रिवेंटिव डिटेंशन क्या होता है कि कहीं दंगे फसाद हो रहे हैं, आपने क्या किया, जाकर के जो दंगा मचा रहे थे उन दंगाइयों को एज अ ग्रुप, एज अ 2-3 पीपल जो सबसे ज्यादा हल्ला कर रहे थे, उन्हें आप पकड़ लाए। तो दैट इज अ प्रिवेंटिव डिटेंशन, जिसमें कि आपने उस भीड़ को सबसाइड करने के लिए ये किया था, अन्यथा ये केस और लंबा और काफी प्रॉब्लमैटिक हो जाता। सो इन दोज केसेस आप ये कर सकते हैं। नाउ फोर्थ वन सेज no law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months unless, अब उन्होंने कहा है कोई भी लॉ जो हमने प्रिवेंटिव डिटेंशन भी किया था कि भाई हमें ये पूरे जो दंगा हो रहा था उसे रोकने के लिए हमने कुछ लोगों को पकड़ लिया है, तो उस कुछ भी हो जाए उनको भी हम 3 महीने से ज्यादा बंदी नहीं बना सकते, 3 months, और उनको भी हम तब तक उनको भी 3 महीने के लिए बंदी बनाने का भी पूरा प्रॉपर प्रोसीजर है। फर्स्टली एन एडवाइजरी बोर्ड कंसिस्टिंग ऑफ पर्सन्स who are or have been or are qualified to be appointed as judges of a high court has reported before the expiration of the said period of 3 months that there is in its opinion sufficient cause for such detention। ये जो 3 महीने का आपने प्रिवेंटिव डिटेंशन किया कि आपने अपने को प्रिवेंट, भाई दंगा प्रिवेंट करने बचाने के लिए आपने उनको जेल में डाला हुआ था, उसको भी 3 महीने से ज्यादा आप एक्सीड नहीं करेंगे। और किन ग्राउंड्स पे कर सकेंगे, जब अगर आपके एडवाइजरी बोर्ड, प्लीज अंडरलाइन दिस वर्ड बिकॉज दीज टर्म्स कैन नॉट बी रिप्लेस्ड, बाकी आप अपने वर्ड्स में फिर भी लिख सकते हो, लेकिन ये एडवाइजरी बोर्ड जो है वही ये पढ़ेगा, स्टडी करेगा, जिसमें कि क्वालिफाइड जजेस होंगे ऑफ हाई कोर्ट, जो ये देखेंगे कि भाई ये 3 महीने जो हमने इनको डिटेन किया है ये फर्दर भी हम कर सकते हैं इफ द सिचुएशन डिमांड्स, बट उसके लिए भी एडवाइजरी बोर्ड का पूरा एनालिसिस चाहिए होगा। Then provided that nothing in this sub clause shall authorize the detention of any person beyond the maximum period prescribed by any law made by parliament under sub clause B of clause 7, then they have talked ki by any hook or crook, even if the advisory board sat down and decided कि हाँ 3 महीने हो गए हैं and he could be detained because ये है आफत करने वाला इंसान, so even if they decide for more extending the period, even in that case it is they have to follow the parliamentary laws, that means the laws laid down in the constitution under the subclause B of clause 7, and they have to go by the law and look forward कि अब इस डिटेंशन में हम कुछ तो सुनवाई करें या कुछ तो हियरिंग हो, जिससे कि पहले ये केस इन फ्रंट ऑफ कोर्ट आए, and it is the court who should decide about the extension of the period for more than 3 months, ठीक है। Then B says such person is detained in accordance with the provision of any law made by parliament and parliament under subclause A and B of clause 7। तो A और B of clause 7 पार्लियामेंट को वो राइट्स देता है कि वो उन्हें डिटेन करवा लें if they wish to, if they find it good enough, reason good enough to detain for longer time। Then fifth one, when any person is detained in pursuance of an order made under any law providing by preventive detention, the authority making the order shall as soon as may be communicate to such person the grounds on which the order has been made and shall afford him the earliest opportunity of making a representation against the order। So now, the moment these authorities who have taken up for him for extending the preventive detention or for going for preventive detention of 3 months or 3 months plus, in both the cases, अगर हमें पता है कि हम इसे 3 महीने से ज्यादा डिटेन कर रहे हैं या 3 महीने के लिए भी डिटेन कर रहे हैं, in both the cases it is the law, it is the right of the prisoner that he should be firstly told the grounds on which उसको डिटेन किया जा रहा है, उसको किन ग्राउंड्स पे जेल में बंद किया गया है, प्लस उसको अपनी को रिप्रेजेंट करने के लिए कि उनको वो अपने जितने भी उसके खिलाफ सब ऑर्डर्स हुए हैं उनके लिए फाइट आउट कर सके, उसके लिए वो कोई भी अपना लॉयर या रिप्रेजेंटेटिव हायर कर सके. Then we talk of the sixth sentence. Nothing in clause 5 shall require the authority making any such order as is referred to in that clause to disclose facts which such authority considers to be against the public interest to disclose. Now, anything that once they tell the reason to the prisoner, but they are in no way compelled to tell it to the whole world or to tell it to the media. Like in the case of Ajmal Kasab, the media was not updated with every movement or every proceeding which was going through. Why? Because it was not in public interest. It could have aroused many religious minded people might go against them. A particular section of people might side with that prisoner. So in that case, keeping that into consideration, ये बहुत compulsory था कि वो public interest को ध्यान रखते हुए publicly ये announcement ना भी करें कि उस पे क्या केस चल रहा है और उसको क्यों further detention किया गया है. They are not answerable to the other people other than the prisoner. The prisoner should know at least. Then Parliament may by law prescribe. Now, Parliament has the law, has the power that it can prescribe what all, let us see, the circumstances under which the class or classes of cases in which a person may be detained for a period longer than 3 months under any law providing for preventive detention without obtaining the opinion of an advisory board in accordance with the provision of subclause A of clause 4. So now here the parliament has the ultimate power that it can detain a person for more than 3 months also. And it need not take the consultation of the advisory board. It can do it if they find it the reason well enough. Agar unhe parliament, that means the supreme power, the law-making body, if they have the consultation and they have come to a conclusion that a particular person can be held for 3+ months, so they need not go for the opinion of an advisory board. Then B, Parliament may by law prescribe now the maximum period for which any person in any class or classes of cases be detained under any law providing for preventive detention. Now, preventive detention का maximum period Parliament के अंडर में, उनके अंडर में ये कोई नहीं प्रिस्क्राइब करेगा, वो पार्लियामेंट ही प्रिस्क्राइब कर देगा, वो पार्लियामेंट ही प्रिस्क्राइब करेगा अगर उन्होंने advisory board की help नहीं ली है तो. Then C, the procedure to be followed by an advisory board in an inquiry under subclause A of clause 4. So now Parliament can make law if whatever proceedings are followed by advisory board, उसमें भी बीच में अपने questions put up कर सकता है और उसमें भी changes कर सकता है. Now we talk of comment. The right under Article 22(2) is available only against illegal detention by police. It is not available against custody in jail of a person pursuant to a judicial order, as Article 22(2) does not operate against the judicial orders. So illegal detention by police could be checked under Article 22(2), but if it is judicial order, then they cannot question it. अगर जज ने या कोर्ट ऑफ लॉ ने ये उनके लिए कहा है कि नहीं ये इतने दिन तक डिटेन होंगे, then nobody can question it. हाँ, if police has illegally detained the prisoner, उसको रोक रखा है अपने पास ज्यादा दिनों से जितना कि उनकी लिमिट है, then even the police authorities can be checked and questioned. ठीक है? I'll just